morning, everyone. Welcome to the third and final day of our fall argument session here in Harrisburg. I'd like to mention that the Pennsylvania Supreme Court is the oldest appellate court in North America, and our roots date back to William Penn's Provincial Court of 1684. Our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722, and last year we celebrated our 300th anniversary with a special session at Old City Hall in Philadelphia. We are proud of our rich history. Over the past 24 years, I've had the privilege of sitting on the bench in this majestic courtroom with these beautiful murals by Violet Oakley, a woman of incredible talent and vision. What a treasure this confluence of history and art provides to the people of our Commonwealth. The Capitol Murals Project was the largest commission ever awarded to an American woman. Remarkably, Violet Oakley, a young Philadelphia artist, was selected for this daunting assignment at a time when women could neither vote nor hold elective office. Ultimately, she devoted 25 years of her life, from 1902 to 1927, to painting 43 murals in our capital. Violet Oakley went on to become one of the most respected artists in America. I trust that no one who works here takes this gift for granted. While there are many things that our three branches of government may disagree on from time to time, I know that our judiciary, along with our legislature and executive branches, all agree that we've been blessed with the privilege of serving the Commonwealth and that our lives are enriched by the beauty of these inspirational murals in our magnificent capital. Before the court crier calls our first case, I'd like to briefly remind counsel of a few matters of protocol. Please approach the podium when your case is called. I will then give a very brief summary of the case. Please then begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel may rely on their briefs for particular issues. In cases where there are multiple parties represented by separate counsel, counsel should not repeat the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues that we want to explore further. Our court does not permit rebuttal argument. Finally, while we have no set time limit for argument, I will advise counsel when we have heard enough, and at that time I will ask that you conclude your argument. Mr. Minner, please call the first case.
MFW Wine Company et al. Versus the Pennsylvania Liquor Control Board. Representing the board, Mr. Howard Hopker. Representing appellees, Mr. John Howard.
In a 2016 amendment to the Liquor Code, the General Assembly permitted a licensed vendor of alcohol to send a special order of alcohol directly to the purchaser, precluded the Pennsylvania Liquor Control Board from assessing handling fees on the purchase, and directed the board to implement a procedure for processing these special orders by a date certain. When the board failed to comply with this statutory mandate, MFW Wine Company sought and was granted mandamus relief. Currently before the court are separate claims brought by MFW Wine for damages, interest, and counsel fees arising from the mandamus judgment entered in its favor. Also at issue are similar claims by other licensees, such as Log Cabin Property, who were aggrieved by the board's failure to comply with the statutory mandate, but were not a party in the mandamus action. In these appeals, we must examine whether Section 8303 of the Judicial Code, which provides that a person who is adjudged in a mandamus action to have failed to perform a statutory duty is liable in damages to the person aggrieved by such failure, permits monetary damages to be awarded against the board, a government agency, or whether the doctrine of sovereign immunity precludes the award of such damages. If that roughly covers it, you can please proceed.
May it please the Court. My name is Howard Hopkirk. I'm a Senior Deputy Attorney General, and I represent the Pennsylvania Liquor Control Board in these two related appeals. The PLCB first maintains that MFW Wine and Log Cabin's claims for damages and attorney's fees are barred by sovereign immunity. Second, even if the PLCB was found to be not immune, the other side is not entitled to attorney's fees under Section 2503 of the Judicial Code. MSW Wine obtained mandamus relief against the PLCB for having failed to implement procedures allowing for the direct delivery of special liquor orders pursuant to Section 305 of the Liquor Code. The important section entitles mandamus damages to a, quote, person who is adjudged in an action in the nature of mandamus to have failed or refused without lawful justification to perform a duty required by law. And you have the statute. It is the PLCB's position that in enacting Section 8303, the General Assembly did not intend to limit sovereign immunity. Sovereign immunity is absolute and is limited only to the extent expressly provided for by the legislature.
Well, then, could I ask Mr. Hopkirk, what is it that 8303 is doing then? Against whom are those damages ever allowed?
So there are other parties that mandamus actions can be brought against that aren't the Commonwealth or aren't covered by immunity. Principally, you'd think of local officials. So it doesn't just get rid of the entire statute and make it meaningless to say that claims against Commonwealth agencies are barred by sovereign immunity.
So in other words, just to flesh that out, so in other words, if a police officer was adjudged to have done something in a traffic stop that supported damages here, that would be allowable, but an agency that simply refuses to comply with a clear statute and court order would not be? Is that what you're saying?
I don't know if I like your characterization, but sovereign...
You could tell me why it's wrong.
I mean, sovereign immunity was established by the General Assembly to protect the Treasury, and it's understood that it's going to apply in cases which might not sound so good. But if it only applied in cases where the government did everything perfectly, well, you wouldn't have a claim to begin with. Our case relies primarily on two decisions of this court. The Commonwealth versus Runyon case and the Meyer versus Community College of Beaver County case. In Runyon, this court held that the Department of Public Welfare was not a person for purposes of the statutory construction act.
Can we not distinguish that case because it was involving the criminal code and not a mandamus action? And if not, why not?
So there's a rule of construction that you look at criminal code matters more strictly, but there's also a rule of statutory construction that you look at sovereign immunity issues strictly. And so the fact that Runyon involves a penal provision and this doesn't should not matter ultimately for how you come out in this case.
And why should it not matter? It's a completely separate issue.
But it involves this court deciding what a person means, and based on sovereign immunity issues, it found that the Department of Public Welfare wasn't.
Do you
And then-
distinguish the participant as defined in the statute different from a person?
I'm sorry.
When you look at, was it 8303? It talks about participants as opposed to entities, persons. Do you distinguish that?
So what I'd say, Section 8303 is a statute of general application. And if you're talking about sovereign immunity, you have to have more express desire by the General Assembly to get rid of sovereign immunity.
I understand, but pursuant to, for example, 2503, rights of participant to receive counsel fees. I'm asking, you have indicated through Runyon, the issue there was whether a government agency is a person. I'm asking you, are you making person synonymous with participant, or do you distinguish the two?
There may be a difference between the two, but if you have a statute that just talks about participant and doesn't discuss sovereign immunity and waiving sovereign immunity, then it's subject to the same type of interpretation where you conclude that the legislature has not expressly indicated that it wants to get rid of sovereign immunity.
What statute, rule, code, or common law do you have to support that position? Do you have any right now?
I'm sorry,
What are you said that we should not compare. Tell me why. You're sharing with me your position, us, but do you have anything to support the argument you just gave us? Anything in case law that we could look at, other than Runyon and Beaver?
Well, I'm sorry, they're in my brief, just general background cases about, sovereign immunity and its applicability, and I think that those do hold some weight here.
Fair enough.
The other thing I wanted to add about the Runyon case is that the General Assembly made a fix where they made Commonwealth agencies available for restitution under the statute. But contrary to what I think my opponent suggests, they did not amend the definition of person under the Statutory Construction Act or anywhere else. So there was no indication in that case at all that the General Assembly wanted to get rid of sovereign immunity.
Counsel, could I go back and ask you, I meant to ask you this earlier. Reading your brief, it seems like your argument against attorney fees is really about your fact-specific eligibility or not. That's what you seem to brief in detail. So I wonder why we're properly doing interlocutory review of that. Why shouldn't that await final judgment?
I think you might be correct, Your Honor. I think we didn't want to waive the issue. Our primary issue is sovereign immunity, and that if we win on that issue, the attorney's fees issue goes away because that would be barred by sovereign immunity also. I think we didn't want the other side to have carte blanche, though, as far as what damages they would get, that if it did go back on that issue, that Commonwealth Court should be instructed to apply the statute
The
properly.
preservation there is your only real concern.
That's what a major concern is. I mean, I think we're correct on the issue, but so- the Meyer case doesn't directly deal with sovereign immunity, but with governmental immunity. But you have the same issues, and this court discussed the governmental immunity issues along with sovereign immunity. And in that case, it involved the unfair trade practices and consumer protection law, and the definition of person included any legal entity, which arguably could cover Commonwealth agencies, but the same logic prevailed that sovereign immunity, the person had not been defined in a way that you would know that the General Assembly wanted to get rid of governmental immunity in that case.
The court thought it was unlikely that the General Assembly would do that.
Yeah, I mean, that's not how they would operate. I think the truth is they weren't really thinking about sovereign immunity at all when they passed Section 8303.
Counsel, can I follow up on that? When we look at the definitional section and the definition of person in particular, doesn't the introduction to the definitional section tell us to determine whether or not the what the context of the statute would indicate to us? So your argument is the definition of person does not include governmental agencies per Runyon, per Vion, and the General Assembly never amended the definition of person after those cases. Am I correct?
Yes, Your Honor.
Okay, but the lead-in to the definitional section tells us to look to whether the context of the statute clearly indicates otherwise. And doesn't a statute that deals with mandamus, which by and large is directed toward assuring that government entities perform their duties, suggest that damages would be available in that context?
Well, first, I'd say suggesting in the abstract is not enough.
Well, let me phrase that. Let me say, doesn't that clearly indicate that person in that context is to include government entities?
So what I would say is that, like I think I said earlier, that there are lots of other contexts where mandamus is broad. It doesn't get rid of the entire statute or all purposes of the statute by saying there's still sovereign immunity.
So your argument is then you get damages in a mandamus action except against government agencies that don't perform their duties. And that's what was intended by 8303.
I frankly, I don't think they thought about it
But
at
we're
all, the
thinking
General
about it.
Assembly, but to get rid of sovereign immunity, they have to think about that specifically, and they have to use language which would make it clear that they specifically were using this statute to get rid of sovereign immunity.
Well, this statute has a long history, and this statute always included Commonwealth agencies. I mean, when 8303 was amended, there's nothing to indicate that the legislature intended to change the manner in which damages and mandamus were awarded. Wouldn't have there been a clear indication that the legislature was abrogating all preceding law?
Well, I think when the legislature reaffirmed sovereign immunity and in the judicial code, they said these types of tort actions are immune, but basically everything else, aren't immune, but everything else is immune. There's no reference to Section 8303 or since then where they have indicated that for that section they wanted to create an exception also.
Except the context of 8303 clearly indicates that Commonwealth agencies would in fact be amenable to not only having damages awarded against them, but having damages awarded for them. Because your argument requires the conclusion that a Commonwealth agency who is aggrieved by the non-performance of a duty is not entitled to damages. You can't change the definition of person from those who are entitled to receive damages versus those who can have them awarded against them.
I think it all goes back to the strict interpretation that should be used involving sovereign immunity.
Okay, so you would use sovereign immunity to change the definition of the word person within 8303 itself.
Well, I think it's ambiguous, particularly because of sovereign immunity, and so you can't just say, it creates an exception. It's a general definition.
I understand, well, but you're saying person would mean one thing in terms of to whom damages could be awarded versus those against whom damages can be awarded. It has to be.
Well, I respectfully disagree. For the attorney fees portion, I've already basically answered our position, and but if there are other questions the court has.
I think you said he's done.
You're finished?
Unless the court has other questions.
Okay.
I would.
Are there any other questions for Mr. Hupker? Thank you, sir. We'll hear from Mr. Papiano.
Good morning, Your Honors. May it please the Court, John Papiano for the appellees here, MFW, A6 Wine, and Log Cabin. Your Honors, this appeal puts very squarely into focus the limits of a Commonwealth agency's perceived power. The PLCB would have this Court believe that in the case of Log Cabin, that it can take unlawfully millions of dollars from the citizens of this Commonwealth, and that the best the citizens can do is compel the PLCB to stop taking the money, and for the stuff that's been taken, they're kind of out of luck, is the PLCB's position. That they are not, that under the mandamus statute under 8303, they're not entitled to damages incident to the relief sought. Why? Because they're the sovereign, they argue, and the PLCB resides up here somewhere, the citizens reside down here somewhere, and that's sort of just the way it goes. And respectfully, that articulation of sovereign immunity is just wrong. It has never been the law of this Commonwealth, nor should it ever be. The Commonwealth Court majority opinion, we of course believe was correct, and we ask that this court affirm. I'd like to first address the issue of sovereign immunity, and with the court's indulgence, I would like to perhaps provide a little bit more context for what sovereign immunity is and what sovereign immunity is not. Sovereign immunity, and you see this in the case law in Dorsey versus Redmond and the first Meyer decision, has always been concerned principally, of course it was imported from English law dating back, centuries, and it was principally concerned, sure, with protecting the Treasury, but as it relates to negligence and as it relates to tort actions, it never barred mandamus claims. Why didn't it bar mandamus claims? It's sort of the big elephant in the room. It's because it didn't bar mandamus damages because the whole point of the mandamus statute was to compel a Commonwealth agency to do what the law commands and to allow someone to be made whole as a result of this Commonwealth agency's failure to act. So we see this in the case law. We see it in the Mandamus Act of 1893, which is 130 whatever years old, said, based by its plain terms, you can compel a Commonwealth agency to do what the law commands, and you shall recover, a successful plaintiff shall recover their damages and costs, period. We see an application of the Mandamus Act of 1893 as recently as 1976 in Allegheny County versus Casey. And to get the quote from the Commonwealth Court correct, it was applying the Mandamus Act of 1893, and it says, there is no question that the Commonwealth is subject to judgment in mandamus, and that the Mandamus Act allows damages and costs without distinction on the basis of the type of government entity against whom the writ is sought. This court affirmed the Allegheny County decision. That's an application of the Mandamus Act of 1893. A couple years later, the Supreme Court, this court in Mail, abolished what was then the common law doctrine of sovereign immunity. And shortly thereafter, the General Assembly didn't want to go that far, and so they codified sovereign immunity, but we didn't go from this court's abolition of the doctrine, which was principally a tort doctrine, to a new doctrine of sovereign immunity codified that took it beyond that which this Commonwealth had ever considered. In fact, in Rank versus Balshi, the Commonwealth Court said the only purpose of the Sovereign Immunity Act was to restore sovereign immunity to where it formerly existed. Supreme Court's Chief Justice Todd acknowledged that in the Dorsey case, and in 1 PACS 2310, the Act itself says you can continue to enjoy sovereign immunity and official immunity. It wasn't like going crazy with it. And so, is there an application of it? There is. 2 years after passage of the Sovereign Immunity Act in City of Philadelphia versus the Pennsylvania Department of Transportation, the Supreme Court rejected PennDOT's argument that it did not have to pay interest in an award of damages because it was the sovereign. It said no. In fact, nobody even questioned, and this is after the Sovereign Immunity Act is passed, whether you can get damages. The only issue there was whether you can get interest. And the majority opinion said, yes, you can get interest. And there was a dissent in that case. And the dissent, interestingly, didn't question whether damages could be awarded. The dissent, in fact, said, of course you can be made whole. The dissent just thought you couldn't get interest. That's 1980. 1987, in Temple University versus the Pennsylvania Department of Public Welfare. This is now 10 years after passage of the Sovereign Immunity Act. The Commonwealth Court says, pursuant to 42 PACS 8303, mandamus is the proper means by which to seek damages. It's a pretty clear statement of law. And we cite the Stoner decision where it makes court makes these unequivocal statements. And if that weren't enough, I would turn the court's attention to Simmons versus Cohen. The Simmons case, a plaintiff sues a high-ranking Commonwealth official. The official claims official immunity, which is found in the same statute as sovereign immunity. And the Commonwealth Court said no. And it was a mandamus action, 8303, and the court said no. And the court says, if the plaintiffs can establish their right to mandamus relief, quote, the principle of official immunity would not be available to shield respondents from liability for damages under Section 8303. This court affirmed that decision. And what's important here, and I don't think it was addressed in counsel's argument, but the court, it's in the brief, the court rejected the argument by the defendant there that it's not sort of fair to award damages for a violation of the statute. And the court said, no, this is like the mandamus statute, and that's the point of the statute. So I obviously there's, to say that sovereign immunity bars mandamus damages would literally be to upend around 75 years of Commonwealth Court and Supreme Court jurisprudence. It's just not correct articulation of law.
Counsel, are you aware of any cases in which mandamus damages were awarded against the Commonwealth?
The Commonwealth itself?
Versus the Commonwealth agency?
You know, interestingly, nothing's jumping out at me. For sure, Commonwealth agencies.
Sure, no, but I'm really just referencing the language in the amended statute that says parens excluding the Commonwealth. And
yeah,
so I'm wondering if there was ever a case in which mandamus damages were actually awarded against the Commonwealth.
I'm not, and I have a lot of cases in my head, but I think in Finn versus Rendell, there may be a suggestion there that, I remember the court very clearly saying the Commonwealth itself is not a Commonwealth agency, and it was drawing the distinction between the two. And so what it said was, therefore, you have to, in a mandamus action, name the specific state actor, because, like, we need to know who it is that's going to do the thing they're supposed to do. And so I'm not sure if...
In that context, the amended statute would clearly just carry forward the mandamus damage law as it was understood.
Yeah, I mean, that was the court's... That's literally the court's application of the mandamus statute after the Sovereign Immunity Act. Yes, yeah. What's not addressed, what wasn't addressed here today, and I think it's important, and frankly, we made this argument because we think it's an important principle of law that the citizens of this Commonwealth deserve, at least to be heard on it, and the Commonwealth Court agreed, that you don't get sovereign immunity if you act outside the scope of your authority. The Commonwealth Court in Bullock versus Horn very plainly said, I can quote it, but it's where an agency acts outside the scope of their authority or powers granted, immunity is lost.
It's interesting. It reminded me of the Lombardo case we heard in this courtroom. Let me ask you, though, looking at the definition of person, government entity other than the Commonwealth, putting it together, is it implausible that 8303 ought to be construed to continue to apply to local subdivisions and agencies and officials, you know, the police officer example for by way of example, but to exclude Commonwealth agencies? Like, would such a construction render the statute ineffectual?
It's implausible, and it would also be the opposite of what the Commonwealth Court and Supreme Court have done since both the Sovereign Immunity Act and 8303. They've literally applied mandamus damages against Commonwealth agencies under 8303 in decisions that were also affirmed by this court. So this would be a new, and
I think that's fair. I think that's fair. I'm sorry to just focus that. Just to say, could you say why you think your position there is a more plausible or faithful construction of what the General Assembly must have meant here?
Yeah, and I think, and there are two separate issues here. One is whether sovereign immunity bars 8303. The answer is no, for the reasons I've stated and for the reasons set forth in our briefing. Then the separate issue, I think what you're getting at, is the person issue, right? Does that somehow change things? And that person issue only comes up in 1991 or 1992 when the General Assembly amended the definition of person to include government entities and exclude the Commonwealth. And so the question then becomes, did the General Assembly in 1991 essentially, by changing the default definition, intend to upend everything that had happened before it as it relates to sovereign immunity, not barring mandamus damages? And I think that is an implausible interpretation, because if you look at the Mandamus Act of 1893, the current mandamus statute, and the 50-plus years of Commonwealth court precedent, there's an understanding, like a very clear understanding in the first Meyer decision from 2010, where it said sovereign immunity doesn't apply to claims under the CPL, which is a contract-based theory. It would basically be upending all of that. And by virtue of a definitional change by the General Assembly in 1991, and I'll address that issue now because I think it's important, what's not really addressed in the PLCB's briefing on the person issue is the question Justice Donahue raised, which is, does the context clearly indicate otherwise? And I think, Justice Weck, you're essentially asking that same question. And it's our contention that the context does clearly indicate otherwise. On the one hand, you know, it's interesting that the PLCB is not really asking for a strict construction of Title I, because if you are, the word Commonwealth, which is excluded, is defined as the Commonwealth of Pennsylvania. It is not defined as a Commonwealth of Pennsylvania and Commonwealth agencies or Commonwealth parties, which the phrase Commonwealth party includes Commonwealth agencies. It's just the Commonwealth, which is defined as the Commonwealth of Pennsylvania. But putting that issue aside, when we look at the context, of course, the purpose itself of the sovereign immunity of the mandamus statute was to, as articulated by this court, was to allow aggrieved parties to recover their damages against Commonwealth agencies who failed to follow the law. But we also cite lots of other issues when put into context as to why the General Assembly, when it amended the definition of person in 1991, didn't mean to upend everything that was happening before it. For example, Justice Dougherty talked about, there's other provisions in Title 42 that deal with attorney's fees, that deal with costs. The Declaratory Judgment Act itself applies to persons. And when I say deals with attorney's fees and deals with costs, what I mean by that is, for example, I think costs are assessed against unsuccessful litigants. The word litigant is defined as a party or person. Party is defined as a person. Attorney's fees may be assessed against participants. The word participant is defined as, I think, a party or person, and again, party is defined as a person. So it all comes back to person. In the Clunan talk about declaratory judgment actions, we cited a case, I think it was Clunan something or other, but the PLCB brought a declaratory judgment act seeking to have their rights under a statute, it was the Sunset Act at the time, declared. And they did it under the Declaratory Judgment Act, like I said, and 42 PACS 7533 says any person who seeks like rights under a statute may bring a declaratory judgment to have their rights declared. And they brought a declaratory judgment action under 7533 to have their rights declared. They deemed themselves to be a person there. The context clearly indicates otherwise. I think also a relevant point here is if the General Assembly, when it changed there's like 55 canons, right, across the Pennsylvania corpus here, and when it changed the definition of person in Title I, there's no evidence that it intended to apply like principally or specifically to mandamus actions. If they wanted to do that, they would have put a definition of person in Title 42. The only evidence in the legislative history as it relates to Title I, and it's in our brief, it's like a pretty innocuous type of thing. It has nothing to do with mandamus damages. And so again, there's just no evidence to suggest that when they changed the default definition of person, They intended it to gut 8303.
And that's why the definitional section starts out with the phrase, unless the context clearly indicates otherwise.
Yes. Yes, and another point I should make is if we are going to apply a strict construction, it makes no sense. So before the 1991 amendment, government entity wasn't even included, right? So the definition of person is corporation, unincorporated association, basically corporate types of entities. There's no reference to government entities or Commonwealth agencies. And yet courts are consistently saying sovereign immunity doesn't bar mandamus claims under 8303. They could have easily said, sorry guys, there's no, person does not include governmental entities, and just barred it. And that's the distinction, I think, Chief Justice Todd's, the Meyer decision in 2014, I mean, as I interpret the decision, you wrote it, but the difference is one of substance. There you have a definition of the word person in the, I forget what title the UTP-CPL is in, but you have a definition of the word person, and the question was, does like other legal entities apply? But Chief Justice Todd, when she was looking at, found that question to be ambiguous, and so it takes something of a holistic approach. There's nothing in the UTP-CPL that suggests it's supposed to really apply to Commonwealth entities. It's in the concurring opinion, they kind of bolster the point that it's about trade or commerce, that it's about sharp practices, of companies. Like, that's the type of thing it's aimed at. That's like the opposite here. The whole point of the mandamus statute is to compel the Commonwealth and Commonwealth agencies to do what they need to do, and for the aggrieved person to be made whole. On the attorney's fees point, I would refer this court, I mean, just 4 years ago in Richard Allen Prep versus, I think, the Department of Education, the Commonwealth Court awarded attorney's fees and costs under 42 PACS 2503 against a Commonwealth agency. This court affirmed it. I don't think there's any principle of law to suggest that a party that acts dilatory can't be sanctioned under Title 42 PACS 2503, that our courts are powerless to act. They do it. They've done it. Time and time again. They've done it a couple years ago. It's another example of why Title 42 and the word person applies to Commonwealth and Commonwealth agencies.
Any other questions? All right. Thank you both very much.
Thank you.
Commonwealth of Pennsylvania versus Jeff Dobson, representing Mr. Dobson, Mr. John Havens, representing Commonwealth, Ms. Catherine Keefer.
In this discretionary appeal, appellant was a passenger in the front seat of a vehicle which was stopped by the police for a motor vehicle code violation. We are asked to decide whether appellant was properly subjected to a pat-down search for weapons pursuant to Terry versus Ohio, where the police officer allegedly had no individualized reasonable basis for concluding appellant was engaged in criminal activity or armed and dangerous, but relied upon the high crime nature of the neighborhood and the receipt of a shots fired call in the area moments before the vehicle stopped. Good morning.
Good morning, Your Honor. Learned counsel, honored justices, my name is Donald Havens. I'm counsel for the appellant, Jeff Dobson. If the court would permit me just a brief word of thanks, I'm a mom and pop law firm. I'd just like to extend a word of thanks to my wife and secretary, Marge, who is seated in the courtroom, without whose help I would not have a brief here today, and who figured out the PAC filing.
That acknowledgement
Which I
is
could not
appreciated.
do. Which I could not do. Your Honor has correctly stated the facts of the case, focusing on Mr. Dobson. He was the front seat passenger. The issue is whether the officer, Officer Duncan, had particularized and individualized reason directed specifically at Mr. Dobson to suspect him of, number one, being engaged in criminal activity. That's the stop under Terry. The seizure. It's also been called by this court and other courts a seizure. And then secondly, reasonable suspicion to believe that he was armed and dangerous. Now, the suppression court transcript is very brief, very easy to go through. You'll have no trouble. I'm sure you've all read it. But it indicates this. Dobson followed the officer's instructions. He was the front seat passenger. He was instructed to remain in the vehicle while the officer ran an NCIC check and what have you. He gave the officer correct information. Now, how do we know this? Because the officer did run an NCIC check and determined that there was no warrant on Mr. Dobson. There was a warrant on the rear seat passenger. We don't know what that is. Officer Duncan did not know. And the front and the driver record came back on him that he was suspended for a DUI. Mr. Dobson made no furtive moves. He was not reaching for something in his waistband. He was not blading. He was not trying to turn his body away from the officer while seated in the vehicle. And he did not try to run. That was the officer's testimony. He did not appear nervous. And no firearms or contraband were in plain view. So, the Superior Court Majority Panel, page 10, wrote this: Dobson is correct that Officer Duncan did not observe any suspicious actions by him, and here's the key word, individually. And that goes back to a lot of the cases from this court and the Superior Court. So what does the Commonwealth do? The Commonwealth is going to go outside of Mr. Dobson, I believe, attempting to meet the totality test that we have there in Terry. And first thing they bring up is evasion. That the vehicle, it was a maroon sedan that Mr. Dobson was riding in, was evading Officer Duncan's vehicle. Now, this vehicle, as you know, had run a red light at 7th and Lloyd. Officer Duncan, I believe, was perpendicular. He was on 7th, and as he was coming into Lloyd Street, he saw the vehicle Dobson was riding in, he was not the driver, run a solid red light. The officer got behind him, activated his lights, and followed him. Was he evading the police? Well, I'd call your attention to page 11 of the notes of testimony. Officer Duncan, who was the only witness who testified that day, and on direct, not on cross, but on direct, said this, line 3. There was actually cars parked along the right side where the car was attempting to pull over. Attempting to pull over. On cross, I brought up the subject of speed, and Officer Duncan's answer was the car was moving at about 5 miles an hour. The car pulled, as far as distance, the car had gone less than a block down Lloyd Street and pulled into Dorian Court Apartments and moved into a parking space. Officer Duncan, by the time he arrived only minutes later, he already saw the driver out of the car, speaking with Officer Kleinfeld, who was already there. Now, it's interesting to note there's nothing in the testimony that this driver was trying to bolt or get away. It seemed that he was cooperating with Officer Kleinfeld.
Counsel, can I ask you to, at this juncture, explain to me what difference it would make if that driver was attempting to bolt vis-a-vis your client?
Well,
so far, I haven't heard
an interesting point
about your client.
Yes, Your Honor, an interesting point, because it's still not individualized and it's towards my client.
Isn't that the question? Does your client have suspicion shed upon him by association with the driver of this vehicle? I mean, that's what I'm grappling with here.
I respectfully answer no, not at all.
Well, it has to be your argument, doesn't it?
Not at all. I mean, I could be sitting in the back of a car, a car driven by an Uber driver. I don't think I should be associated with whatever he's associated with.
Yeah, those aren't the facts here, though. I mean, those aren't the facts here as found by the trial court. This wasn't an Uber.
No.
What about, it's not like your client was arrested. The police officers, as I understand what the trial court was saying, found as fact, which is really what I'm concerned about, unless you're going to, going through the record is interesting to determine whether the factual findings were supported by evidence in the record, but sticking with what the trial court found, as I understand it, the frisk of your client was incidental to the arrest of the other two. And the idea was the frisk was because the police officers were concerned about their safety. And doesn't our Constitution allow police officers to ask anybody in the vehicle when they're making an arrest to exit the vehicle for their personal safety?
I believe this court, and I believe it was in Adams, indicated that officer safety cannot replace reasonable suspicion in the Terry paradigm. Can't replace that.
So how if an officer is pulling over a vehicle and according to the trial court the vehicle doesn't pull over immediately, travels slowly, avoids a blocked intersection and turns, and then upon finally coming to a stop, as the police officers requested, the driver of the vehicle gets out of the vehicle as opposed to staying in the vehicle. It's in the area, not, put the high crime factor away, but it's actually in an area where police were reporting 2 shots fired. And the police officers, in the context of running, find out that at least 2 people in the vehicle have records and have to make an arrest. You're saying that they should not be permitted to confirm as they're trying to make an arrest. They have to have, like, what level of reasonable suspicion that each individual has a gun for them to just be concerned about their safety? I mean, do they have to have a suggestion that they're going to get out of the car and punch them? I mean, I'm just trying to figure out where you got to put yourself in the situation of a police officer. And this is I'm rambling on, but I think you understand what I'm getting at is I'm not sure the standard you're proposing is a standard police officers could ever meet if they're trying to protect themselves in making a stop like this.
Yes, well, I respectfully disagree that as to your understanding of the facts of the case. Each of these occupants, 3 occupants, a driver, front seat passenger, my client, rear seat passenger, were all fully cooperative as far as we know from reading the notes of testimony
I'm not looking at
officer.
Unless you're telling me the trial court's findings are not supported by substantial evidence, I'm sticking with the trial court findings.
I would say I totally disagree with the trial court's findings insofar as they report that there was evasion on the part of the vehicle that my client was not driving. It went less than a block. It's going 5 miles an hour. It's looking for a place, in the officer's own words, for a place to pull over, and it finally does pull into Dorian Court Apartments. It goes less than a block. It goes less than a block. And when it did pull over, I asked the officer if that, in fact, is the place where the owner of the vehicle lived. The officer did not have an answer to that. And as far as I know, I don't think this vehicle was ever.
Counsel, could I follow up on my colleagues' questions? Because I think they were probing an interesting issue. Is there or is there not any action by others in a vehicle that can be used to establish or impute reasonable suspicion to another? So suppose there are 4 people in a car, and 3 of them are the police observe 3 of them waving guns out the window. It's not your case, but work with me here. So can the police use that observation to pat down the 4th passenger? Are you with me on the hypothetical?
Yes,
I'm just trying to tease out whether there's a scenario where actions of others can be used to support reasonable suspicion as to another passenger, like your client here.
Well, in this particular case, as the court knows, this officer was dispatched originally to canvass for reports of gunshots. He was looking, in his words, for proof that there were gunshots. He was looking for bullet holes, spent shell casings, victims. Did not find that when he stopped this particular vehicle. Did not find it in the vehicle, did not find it in any of the occupants, and including specifically for our purposes, Mr. Dobson. Found none of that connecting him with any criminal activity. There's no report. By the way, the report that the officer received, which is secondhand, of course, never mentioned there was a vehicle involved at all. So there are major differences between this and a lot of other cases. And in your scenario, maybe the Commonwealth could argue that that is just one more arrow in their quiver for the totality test. I don't know how I would counter-argue that. I would still point to the individualized and particularized suspicion that has to affix itself to Mr. Dobson. I would still maintain that.
I think we understand the case. Are there any further questions for Mr. Havens?
Well, I did have one. I wasn't going to ask it yet, but if you're going to conclude, if I could ask it now, Chief. It's just that I want to know whether your argument on the high crime area issue, that
yes.
Justice-elect McCaffrey discussed in dissent, is it your argument now that we should not consider the high crime area designation at all, or is your argument that that designation by itself is insufficient to establish reasonable suspicion?
Yes, when Officer Duncan was questioned on direct, the only reason that he articulated for the stop, for the seizure of Mr. Dobson and the frisk, was that he said the area he was in, pages 18 and 19 of the notes of testimony, the area that he was in. And it goes in the Commonwealth's brief and goes into some detail about high crime areas. But if that is found to be standalone, if that is found to be the only reason for seizing Mr. Dobson, searching Mr. Dobson, the courts do not support that. As a matter of fact, the Commonwealth itself, in its amicus brief, stated at page 13, it says, of course, this does not mean that everything that occurs in these areas is criminal, and officers should not be able to justify their actions and decisions solely on the basis of past criminal activity in a certain area. Indeed, the law already prohibits this. And I would suggest to the court, if this is the only reason, the only one articulated by Officer Duncan, the only witness at the suppression hearing, then what in effect we would be doing is setting up zones of Fourth Amendment protection, depending on where your car is stopped in a traffic stop. You'll get more or you'll get less Fourth Amendment protection. And there's just one other thing I'd like to say in closing, that is this, a broader consideration. What kind of activity, or I'm sorry, what kind of behavior do we want to encourage in the occupants of a motor vehicle at a traffic stop? I thank the court for its attention.
Thank you. We'll hear from Ms. Kiefer. Is it Kiefer or Kiefer? Kiefer, Ms. Kiefer, welcome.
Thank you. May it please the court, Catherine Kiefer for the Commonwealth. In assessing whether there was reasonable suspicion, no single factor may be considered in isolation. This court must remember, as the U.S. Supreme Court has cautioned in Michigan v. Long, that police are dealing with unknown individuals at close range when the officer must make quick decisions how to protect himself. Indeed, as that court said in Pennsylvania v. Mims, it is too plain for argument that police face inordinate risk in car stops, as it appears that a significant percentage of murders and police officers occur when the officers are making such stops. Here, police officer Duncan confirmed during the suppression hearing that he feared, based on the totality of the circumstances before him at that moment, that defendant may have a weapon. That fear was objectively reasonable, given the spatial and temporal connection to the shots fired call that occurred moments before and only a block away, the late hour, the car's evasive behavior, the driver's immediate exit from the car to separate himself from the two passengers who remained in the car, and Officer Duncan's own particularized experience, not with a general area like the city of Chester, but with that particular small area of blocks where he himself knew from his experience of pervasive shootings, violent crimes, and drug dealing.
Counsel, could I jump in and ask you?
Please.
When the officer was asked why he believed this individual, Dobson, could be armed and dangerous, the entirety of the officer's answer was, quote, being in the area that we were currently in,
yes,
end quote. How does that satisfy the constitutional test under our precedents?
I think that answer, that particular line of the transcript is accurate, but I think it was part of a larger conversation where he pointed out additional factors that were at play. He also discussed that, he talked about the shots fired call. He talked about his personal experience. He talked about how the car, when he put the lights on, slowed to about 5 miles an hour, but then, unlike the telling of co-counsel here, he actually sped up again and then avoided the second officer who blocked his path.
This is the driver you're talking about.
This is the driver.
What
yes.
What specific actions, aside from the high crime area, which the officer testified to, can you point to that at the time suggested in any way that Dobson was armed and dangerous? What did he do, Dobson, that would justify a belief that he was armed and dangerous?
I believe that you can't ask that specific question because that's not what Terry requires. Terry requires that we look at the totality of the circumstances. Pennsylvania Superior Court has said that in situations of cars, you may kind of impute, as was suggested earlier, the acts of one toward the acts of others because police don't know. It's dark. The car is driving away from them and away from the area of the shooting. And as the U.S. Supreme Court and this court has said, when there is tension between officer safety in a traffic stop situation and the small infringement on the Fourth Amendment rights or the Article I, Section 8 rights of a potential defendant, we have to give credence to police officer safety. That has to be the priority.
And how does your just one more follow-up?
Sure, of course.
How does that argument give appropriate deference to our decision in Commonwealth versus Alexander?
Well, Alexander was a case that deals with searching a car, not patting down a person, and it requires probable cause, not reasonable suspicion. So I don't think the two really have much to do with each other. It's a different type of infringement, and it requires Alexander requires a much higher legal standard than the lower reasonable suspicion standard necessary in the Terry context.
Counsel,
Sure.
my concern is Terry and the progeny of cases requires an officer to believe that the individual to be patted down is in, what's the language? The individual is presently armed and dangerous. That's just taken from Commonwealth
Sure.
versus Gray. What facts do we have that the officer believed that he was presently armed and dangerous? Because in the notes from the transcript from the motion to suppress, the Commonwealth asked, okay, can you detail for us and tell us if you recovered anything? And the officer's response was, quote unquote, after doing the pat down, I immediately recognized a bulge. Immediately after the pat down. Doesn't that fly in the face of our common law?
In that he didn't believe, I just want to make sure I understand your question. He didn't have confirmation that the danger was a gun until after he committed, or after he conducted the pat down. Is that your question?
Well, yes.
Okay.
The issue is where is his reasonable suspicion that Dobson was immediately armed and dangerous, other than being in a high crime area as a passenger, coupled by the fact that he was very candid and honest to say it was only after I did the pat down, I didn't know why I was patting him down, but after I patted him down, I felt the gun.
He said that he patted him down because he feared that he had a weapon.
His response is, after doing the pat down, I immediately recognized a bulge.
Right.
Immediately after.
Right. He recognized that the item he felt was a bulge in that he conducted a proper Terry stop and he didn't manipulate the item or otherwise go beyond what's permitted in a Terry pat down. But I don't think he had no reason to fear for his life until the moment that he conducted the pat down.
What was the basis for his fear of this individual?
The totality of the circumstances.
That he was a passenger in the back seat in a high crime area. So
In a car that was going away from the area where there had been shots fired, in a car that was acting evasively, in a car where the driver very weirdly immediately got out of the car the moment he arrived, in the dark where he cannot see what the remaining two passengers in the car are doing.
I'm from Philadelphia. I live in Philadelphia. I could be driving. I could have my wife driving me while I'm holding my niece or nephew.
Right.
I'm driving through parts of South Philly.
Yep.
And you're telling me because my wife slows down because we see a cop car, and we look to see if there's anything happening because we're all from South Philly.
Right.
And then we realize we don't know anybody. So she accelerates because I went from 5 miles to 10 miles in a 15-mile limit neighborhood street. You're telling me because I happen to be, instead of 2nd and Jackson, I'm at 5th and Mars, which everybody knows, quote-unquote, is high crime.
Yep.
I'm at 6th and Mars. You're telling me they have a right to stop, pull me over, and pat me down because my wife accelerated just based upon rubbernecking to see if there was a crime going. And then we wait, and we're still only going. We've accelerated from the 5 miles, but I'm within the legal speed limit, and I'm in a bad neighborhood.
If your wife had committed a traffic violation, which everybody accepts happened here, and if that, unfortunately, totally innocent scenario had occurred within moments and 1 block of a call for shots fired, then I think, yes, the police are absolutely justified, if they are already making a traffic stop, to be reasonably concerned for their safety in such a scenario when that series of individual factors, none of which maybe on their own would have been sufficient, but when you put them together, properly led this officer, as he testified at the suppression hearing, to fear that the guy was armed. I think, yes, that small intrusion on you or your wife or your grandchild, they probably wouldn't pat down your grandchild.
I don't have a grandchild.
I'm sorry. I think that small intrusion is justified, and that is the exact balance that this court and the U.S. Supreme Court have said in the past is acceptable and expected because this is such a dangerous scenario for police officers.
Counsel, can we focus again on Mr. Dobson? Is there any indication that there were any furtive movements on his part?
There are not, and I think...
And isn't it also true that he was totally cooperative with the police officer?
That is the indication of the testimony. And I'd like to make
Well,
something.
indication that, so he was totally cooperative.
He was cooperative, and there was no indication of furtive movements. However, I would say that simply because those are factors that are commonly found to support reasonable suspicion, there's absolutely no requirement that they must be found for there to be reasonable suspicion.
So he could do nothing wrong. He could be totally cooperative. He could be a A1 citizen, and they could still pat him down.
If there are other circumstantial things going on in the totality that would lead an officer to reasonably believe that his life may be in danger, yes.
Well, what's the end point of that? So somebody rolls through a red light. It seems like so long as the officer uses the mantra high crime area, anyone in that vehicle is ipso facto considered armed and dangerous. Isn't that a backpedaling on where the precedents have gone in recent years?
I don't think it is, and I think maybe it would be useful to remind this court that the federal courts have something called the automatic companion rule, which has been before you guys before, but you haven't ruled on it. It wasn't squarely what's presented. But the Superior Court has, and the Superior Court rejected the automatic companion rule, which was a Ninth Circuit case, which says that per se, not paying attention to any of the surrounding circumstances, doesn't matter what they are. The automatic companion rule suggests that all companions of an arrestee may automatically be subject to a pat-down. No context whatsoever. The PA Superior Court, when it's been before them, has rejected this and said, no, we don't want there to be a per se rule. Context matters. You have to meet Terry. That Terry would be a higher burden than a per se rule. And so I would suggest that that's probably an accurate description of what was going on here. It wasn't that they just did it for no reason whatsoever. It wasn't a per se, you're in the car, therefore pat down automatic. It was, there are a wealth of circumstances going on here. The police officer needs to make a decision about his safety in a very brief period of time, and the circumstances here warranted patting down everyone in the car because they don't have enough information to distinguish, are they involved in the shooting? When they're slowing down and kind of pulling over but then speeding back up again, is there something going on? Are they passing a gun from one person to another? And he's not expected to put those questions aside and his safety aside in that circumstance.
Ms. Kiefer, when you talk about the totality of the circumstances, can we consider the fact that officers are, from time to time, shot at traffic stops? Is that one of the factors that can be considered in the totality?
I think it must be, yes. I think that's what underlines both the U.S. Supreme Court and this Court's prior decisions.
Counsel, what does your theory do with the concept of individualized suspicion? So far, you're apparently arguing that there need be none.
I think there needs to be individualized to the circumstances that are going on, as opposed to, say, a per se automatic pat-down rule. I do not believe that there should be a requirement that it has to necessarily, that all of the reasonable suspicion circumstances have to emanate from that person, because it's an unworkable circumstance for police.
Counsel, that's what individualized suspicion is. It's individualized to the individual. I mean, the Article 1, Section 8 in the Fourth Amendment protects individuals. You're saying
I think it's individualized.
What this defendant did has no relevance in the equation that you're explaining to us. I'm just trying to understand the scope of your argument here.
It's a very fair question, and it's a tough call. But I believe that when the police are faced with a scenario where they cannot distinguish group suspicious behavior, such as what's going on by the driver of a car and what's going on in a car, from the individualized people within the car, we have to, because it comes back to that balancing of police officer safety versus the small intrusion, we have to view individualized suspicion in that case as individualized to the scenario and not necessarily to the person. Different from, say, if the police approach a group of people on a sidewalk and they're all standing around and some of them do things that lead the police to feel that they need to be patted down and others don't, because the police officers can view the people individually. Here there's no opportunity to view the actors in the car as anything other than the singular passengers.
Are you asking us then to create a new doctrine that says individualized suspicion no longer means as to the person, but rather as to the circumstances?
I'm not, because Terry said that from the beginning. You don't have to create anything new to affirm the Superior Court here. Terry itself didn't rely on particular suspicion of acts of the individual who got patted down. Terry relied on the circumstances that were going on that the police observed outside of the actor. So this
they were collective activities of all of the individuals who were involved in Terry. It's not that one of them was standing there doing nothing.
Correct.
There was movement among all three of them, and interaction among the three of them that raised a specter. There was conduct on the part of all of those individuals. Here, what we have is purely innocent conduct on the part of Mr. Dobson. And so I think the question is, you're suggesting that we do not look at the conduct of the individual at all in this equation.
I'm not saying that, respectfully.
Well, then what did Mr. Dobson do
Mr. Dobson's
to create
I'm sorry.
an
Yep.
individualized suspicion?
He's a completely blank slate. He's a black hole of information. So given the fact that you can't separate what he may or may not have been doing or intended within a car where the officer can't see in it, but the actions of the car itself reasonably raise suspicions, I think that falls under the totality of the circumstances test.
Let me see if I can weigh this, because I'm just intrigued by this argument. He wasn't a black hole. He was an individual who cooperated with the police, made no furtive movements. There was no conduct in this case on his part that would trigger any of the circumstances that we've seen in other cases that indicate a reasonable suspicion. He is not a blank slate. He is an individual who has exhibited the qualities of a cooperative citizen under these circumstances. Your argument is ignore it, because it could be that that's a sham. I mean, we're not a blank slate. We have somebody who was cooperative with the police.
He was not a blank slate during the much smaller period of time that Police Officer Duncan was actually interacting with him. But he was a blank slate during the 2 to 3 minutes beforehand when the police officer was taking in all of the information about the surrounding circumstances of the car evading the police, it driving away from the area where the shots were fired.
And all they knew was all the police officer knew was Mr. Dobson was in the car with these people.
Correct.
And then that's a good point. That's all they knew. And when asked what led the officer to believe Dobson could be concealing a weapon, the officer replied, candidly, quote, the area he was currently in, unquote. So you seem to want to improve upon the fact record in order to expand our doctrine in a way that would say anybody in a car is subject to search. And I just don't know of a case in Pennsylvania that would support that.
My reading of the record, Your Honor, is broader than that. That was the answer that that the police officer gave to that particular question. But the trial ADA, my memory is, asked additional questions around, either before or immediately after that one, that sort of fleshed out what more than just, the car was in a high crime area. So I think the record actually was a little broader than that.
But I guess I didn't read the police officer's testimony that narrowly when the police officer testified the area. I read it to mean not sort of this abstract, well, we have this map in our headquarters and we have a circle around this high crime area and I was there and I just saw a car drive by. I thought he was referring to the fact, this is an area that I was immediately sent to, where shots were fired. That does have a history of violence and things like that, but the idea that when he was saying area, all he meant was there's a circle on this in our headquarters and it's a high crime area.
I would agree with that, Your Honor. I believe it was very specific to this area where shots were fired 2 minutes ago.
Allegedly shot.
Allegedly, correct.
But they said enough of a report that they sent police officers out into a shots fired
Yes.
to protect the public.
And also, sort of more specifically than the, Philadelphia's a high crime area, Chester's a high crime area, he testified very specifically to his personal experience, responding to and doing police work regarding shootings, violent crimes, and drugs in that immediate few block area. So it was both of those.
Apply that now to Justice Doherty's hypothetical.
Sure.
So, Justice, now apply that in the South Philadelphia neighborhood that Justice Doherty was referring to.
Yep.
Officers got a report, no reason to doubt it, that shots were fired. He's in a car that rolls through a red. The car is pulled over. He's not the driver. He's subject to search, in your view of the law. Is that right?
If the car pulled over without evasive behavior? I mean, I think that's a factor that matters, and I didn't hear you say that.
Without evasive behavior?
Yes,
Okay.
because here there was evasive behavior.
Oh, it was evasive behavior because the car, what?
Because the car slowed, but never came to a stop.
Assume that's the
Then
case.
it sped up, then it turned to avoid the second police officer that blocked its path.
Okay, yes, all of that's in the case.
So the exact same scenario.
Yes.
Then yes.
Well, and the driver of the vehicle exits the vehicle without being instructed to remove
Right.
himself from the cabin.
Right.
Where a gun could very well be concealed.
Right, and now the police officer's attention has to be separated into two separate people, which obviously puts them at more risk because they can't be looking here and there at the same time.
I think we understand your argument. Are there any other questions for Ms. Kiefer? I have one. How long have you been with the District Attorney's Office?
So I've been at the Delaware County District Attorney's Office since DA Stolzheimer began in 2020, but I was at the Philadelphia DA's office for many years before that. So
Okay. I was going to ask if this was your first time arguing before the court.
it is, actually. I was in the federal litigation unit for most of my time there, so I did federal work.
Well, welcome to the court.
Thank
You got
you.
to argue against an experienced pro, and
Yes.
you did nice jobs.
Thank you all very much.
Thank you. Thank you, counsel.
Joseph Caldwell Jr. versus Philip Jaurigue, representing Mr. Jaurigue, Ms. Hillary Renee, representing Mr. Caldwell Jr., Mr. Jeffrey Priscilla.
In this appeal by allowance, we consider whether, under our 2005 decision in AS versus IS, child support obligations extend to a third party, the paramour of the child's deceased mother, who obtains partial physical custody rights but no legal rights to the child.
May it please the court. My name is Hillary Renee, and I represent appellant non-parent Philip Jaurigue. I'm here today with co-counsel Matthew Shapiro, Melissa Blanco, and Amanda Fratt. I thank the court for allowing us to present this appeal. For over 50 years, Pennsylvania courts have repeatedly stated that non-parents do not have a general obligation to pay child support when they gratuitously take on the burdens of custody. This court's decision in AS versus IS did not change this well-settled law. Today, we're asking you to affirm that over 50 years of precedent and reverse the Superior Court decision that, supposedly relying on AS versus IS, turned that precedent, quite frankly, on its head. The 50 years of precedent that came before AS, and which AS expressly embraced, is premised on a straightforward piece of Pennsylvania public policy. Children need stability and continuity in their lives. And a bedrock of that stability and continuity is a child's ability to maintain a post-separation relationship with a third party with whom the child has developed a significant bond. This bond is so important to a child's life that Pennsylvania courts have stated such third parties not only have the right to visit the child with whom they have such a special relationship, but also that the non-parent's right to visit the child must be jealously guarded. Pennsylvania has also, for a long time, followed the policy that non-parents who gratuitously take on the burdens of custody in an effort to maintain stability in a child's life should not have a legal support obligation for doing so. Again, this court's decision in AS versus IS did not change this well-settled law. It did not allow the imposition of support obligations on non-parents who seek custodial rights less than those held by a biological parent or adoptive parent. It simply provided a narrow exception to an anomalous situation that created a tiny bullseye. A step-parent who took so many significant steps, in fact, made a relentless pursuit of equal legal and physical custody that he effectively became a legal parent in all but name. The limited nature of the court's decision in AS is exemplified by 3 limiting phrases used throughout the opinion. All the rights of parenthood, the same legal and physical custody rights that would naturally accrue to any biological parent, and rights equal to those of the child's parent.
Counsel, is it fair to distinguish AS from these facts? In that particular case, the step-parent had legal custody.
Correct, Your Honor, yes.
And in this particular scenario, your client did not have legal custody.
Correct, and he did not ever seek legal custody.
Correct. So the pivotal position that this court should consider is whether an individual who is in possession of some half-legal custody should be required to a non-custodial person who shares joint legal custody may be subject to support, but an individual who stands in loco parente that has physical custody should not.
I believe that's correct, Your Honor, and I believe that's what the 50 years of precedent that both the Superior Court has established and which has been affirmed by this court expressly in AS. So,
could I follow up just briefly on your response to Justice Dougherty? Is it appellant's position that we should establish a bright line rule that legal custody can bring you within AS, seeking legal custody, but that if you're not seeking and not granted legal, you can't be subject to a support order? Or would you advocate for a case-by-case determination?
Your Honor, I think AS did establish a bright line rule. It said that under these circumstances, where a parent, where a person, not a parent, where a person has repeatedly litigated for equal physical and legal custody, so to go so far as to prevent the mother in that case from relocating. In that situation, I think that was a very narrow exception which did create a bright line rule.
I agree it's narrow. And by the way, it was decided the day before Justice Donahue, Justice Dougherty, and I joined the court. Justice Todd and former Justice Stevens joined Justice Baer, and Justice Saylor dissented. But anyway, very interesting case. You say it established a bright line rule, but it was attendant to its circumstances. That's why I'm asking, and I take it you would not say that seeking legal custody is a bright line, but that you want us to continue a case-by-case analysis? Or can we distinguish this case from AS and say, here, no legal was sought, and therefore, or do you want us to look at whether somebody was repeatedly seeking rights and persisting? What is your test? Is there one?
In this case, Your Honor, I don't believe we even come close to AS, to the factors in AS. So when this court's question, which is, does the court's holding in AS versus IS extend beyond the facts of that case and create child support obligations in third parties who seek and obtain rights less than those held by a biological parent? The answer is no, it doesn't. And this case here does not meet that test in AS.
But we're deciding this case not just for your clients, but for the Commonwealth of Pennsylvania. So that's why it's so important when Justice Wecht asks, what kind of a rule are you asking us to establish?
On that point, I'm even less further attenuated from AS than Justice Wecht, Justice Donahue, and the Chief Justice, by miles. if I didn't have AS in front of me and I just looked at the statute, the General Assembly said parents.
Correct.
That's
Very clearly.
Very clearly it said that. And the General Assembly uses the word parent or parents in other contexts when it comes to child matters, child custody matters and adoption and things like that as well. If I were writing from a clean slate, which I understand that I'm not, and I do think AAS's facts are more like the whole parent by estoppel argument than anything
I agree, Your
else. It seems to me that a parent is one whose rights can only be terminated by a termination of parental rights proceeding. If your rights, whatever they happen to be, legal, physical, whatever they happen to be, can be terminated, you do not have to go through that process of terminating parental rights, then you're not a parent.
Correct.
That seems to me a very straightforward statutory construction. We don't get into, well, what's the public policy? It's kind of parent-like. It's, those kind of things. And we stick simply with the statutory language. Tell me why that approach isn't, why I'm off base or not on base?
I don't believe you're off base, Your Honor, and I agree with that. I think the support statute under 4321 is very clear to say that parents, and only uses the term parents, are liable for the support of their minor children, essentially.
I mean, the General Assembly knew what legal custody was and physical custody
Correct.
was, and because they have all these custody proceeding statutes and things like that. Obviously, they know that. They could have defined parents as any person who has partial legal or full legal custody of a child.
Correct. I'm sorry, Your Honor.
But they use the word parents, and that word seems to me in these new statutes that I'm learning about fairly consistent meaning across the board from the General Assembly.
It does. I agree with that. And the General Assembly, like you said, clearly understands the definition of parent, because if you look at the custody statute and you look at who has standing to bring a custody action, parents is one group of people who can bring a custody action, but then there are also different groups of people, persons who stand in loco parentis to the child, a grandparent who doesn't stand in loco parentis to the child, and there's sort of a catch-all for other people that meet certain conditions. So the General Assembly appreciates the different categories of people, and yet did not include any of those other than parents in the support statute.
Okay, so you've answered Justice Robson's question, which may indeed answer Justice Wex and mine, but could you answer Justice Wex and my question, what rule do you want us to establish?
So, Your Honor,
Is that it, the one you just answered?
I would argue, if I could go a little bit further and say that there have been, under Pennsylvania law and the precedent established by this court and the Superior Court, other doctrines of parentage, I'll call them, over the last 50 years. So if you look at the technical meaning under PA law of parentage, it's established in 4 ways: biological parents, adoptive parents, presumption of paternity, and the doctrine of paternity by estoppel. So I think you do have to look at those as well. We're not going to turn away the years of precedent,
But not in loco parentis.
not in loco. I'm sorry, just so it,
Not in your category you just listed, you are not listing in loco parentis.
no, in loco parentis, I think for custody purposes is important for standing, but that's as far as it gets you in loco parentis. It gets you standing to bring a custody action, but it doesn't actually give you any custodial rights. Then it becomes a fact-sensitive analysis, right? So to come back to your question, your Chief Justice, about what a bright line rule should be, I will say, I mean, I'm an experienced family law practitioner. I've been doing this for almost 30 years, but I don't believe I'm the correct person to answer that question. And I think that's a question for either this court or the General Assembly.
I think by now that you've answered it by default through your resistance, which is fair, to our invitation to advocate for a bright line rule, and by implication, I think you want to consign us to a continued case-by-case meandering through AS, like, in other words, your opponent, under your construct, I take it, would be free in this case or in future cases to argue why it's more like AS than like our main body of cases. And I'm a bit surprised, I'll say, that
Wasn't what
you,
I expected either.
yeah,
I expected that you would be arguing for a bright line.
I do believe there should be a bright line rule. What that bright line rule should be, I believe, is more appropriate for the General Assembly than for me. But I do believe that the legal custody piece of it, so legal custody and physical custody obviously have very different meanings. Legal custody being, who has the right to make decisions as to medical, religious, educational for a child. What I would consider, and I believe public policy considers, the most fundamental rights of parenthood. Physical custody is who gets to spend time with the child and how much time do they get to spend with the child. So, Justice Weck, I guess circling back to your question from earlier, I do agree that the legal custody part is very important in terms of any bright line rule. I think the physical custody part and how much time somebody has is harder. Legal custody is clear. So, for example, in the current case, Mr. Jaurigue, while he's allowed to spend time with the child, he has no ability to decide where the child goes to school, what type of school she goes to. He doesn't get to see her report card. He doesn't get to make any medical decisions. He doesn't get to decide what extracurricular activities she participates in. All he gets to do is go to those things that her father decides she can go to.
We understand all that because we've read your case. I guess what a couple of us are trying to nail down is, would that, in your view, end the case? And you don't seem to be saying yes, period.
I'm sorry.
The fact that he neither sought nor obtained any of the legal custody rights.
I do think in this case, right there, that ends it. I think the Superior Court's focus is misplaced on saying, this person has a lot of time with this child and therefore it goes beyond. I think the legal custody part of it is huge, and I think without the legal custody, you cannot have a support obligation.
Well, I guess that's the question. I mean, you're sort of hedging even this, which I think is a sort of an easy question for you to answer. Unless legal custody is awarded,
Correct.
There's no possibility of having to pay support.
Correct, and I will not hedge. I will answer your question.
Okay.
I agree with you,
Okay,
Your Honor.
But is the follow-up true? That is legal custody alone sufficient to make you a parent for purposes of the statute?
I don't believe so.
But that is the follow-up question, because would you agree then that you would like a rule that would say no legal custody, no support in play? However, if there's legal, then AS is arguably in play, that they can litigate this.
Yes.
Is that your position?
Yes. I mean, I think AS specifically says if you have anything less than equal, it uses those phrases over and over. All the rights of parenthood, the same legal and physical custody rights that would naturally accrue to any biological parent, and rights equal to those of the child's parent. So I think, correct, Your Honor, legal custody is step one. You have to have legal custody, or we don't even go down the other path. As far as physical custody, I'm hesitant to say that it should be fact sensitive, but I don't know, practically speaking, other than to say
there are parents that don't have physical custody.
Correct, and that's why
Physical custody is pretty much irrelevant.
Correct, Your Honor, and that's why I'm hesitant to say it should be, the physical custody piece of it should be 5% or 40% or 50% or whatever that and how you figure that out is a wide open area as well. So, right, you are correct that there are many parents that don't have shared physical custody or don't have, even 10% of physical custody for a variety of reasons. But the difference between some of those people is those are parents. So they have an obligation regardless under the support statute. We're now talking about third parties, and I do think that makes it different.
Let me throw out a question then. Following Justice Brabson's comment, the statute specifically says parent. What of the scenario of a step-parent who has not adopted their partner's child? Are they subject under the parent statute?
I don't believe so, Your Honor.
Okay.
All right, any other questions for Ms. Mooney? Thank you very much. Let's hear from Mr. Grisilli.
Thank you, Your Honor.
Good morning, Your Honors. My name is Jeffrey Grasillo. I represent Mr. Caldwell. He's in the courtroom right now with his current wife. I would also like to thank the opportunity to appear before all of you. May it please the Court. The issue before the Court, obviously, is whether or not the Court's holding in AS v. IS extends beyond the facts of that case and creates child support obligations in third parties who seek and obtain custodial rights less than those of a biological parent. My view is the answer to that question is a resounding yes. Appellee, in this case, believes that the Superior Court soundly applied the law of AS v. IS and all related cases to the facts of the case before the Court today. Now, in unpacking that, first, why do these child support obligations extend to third parties who seek and obtain these rights? Well, first, I would ask the Court to look at the Code, Title 23, 5324, where it's discussed the standing. It's just been previously argued by Ms. Monet regarding the standing. We have to look at that. And there's 4 scenarios that would allow for standing for custodial rights. And that's number 1, a parent. Number 2, an individual standing in loco parentis, which has its own subset body of law for determining the standard to obtain in loco parentis. Number 3, grandparents, as they're in a unique scenario. And number 4, a somewhat of a catch-all provision that, at least from my perspective as a family law practitioner, is usually intended for individuals that are parents that are exhibiting some type of drug abuse or substance abuse issues you'll see where they're no longer in care or control.
You're debating, or you're reminding us of the custody statute. Before we get there, though, we have to ask you about the support statute, which is what we're litigating here today. So the General Assembly said parents are liable for the support of their children.
Yes.
And the majority in AS elasticized that a bit, and you want, it seems, to elasticize it even further. Do you have a bright line rule that would allow that further elasticization to remain within some intelligible limits, or are you just advocating for a wild, wild west where every common pleas judge could sort of do what he or she thinks is fair, and where would that end?
Yes, sir. Thank you. It's a very good question. I do have a bright line rule, calling it the Caldwell test for simplicity. It's extending the principles discussed in ASVIS. And I can get back to ASVIS. I'll tell you the rule, but I believe that it's 3-pronged in nature. Number 1, that there was sufficient affirmative steps, and this, for clarity, is in regard to in loco parentis only, in my view. Sufficient affirmative steps, number 1. 2, that individual took to obtain substantial custodial rights. And number 3, over the objection of a natural parent. When applying that, I can take a look at the case of McNutt, which is cited by the appellant, which dealt with this, I'm going to call, public policy argument that we want to make sure that there's gratuitous love. We hear this language of incentivizing people to step in and in loco, care for children, child rear, all the important public policy positions that the Commonwealth has to ensure children are cared for. In that case, quickly through the fact pattern, a stepfather marries a woman. She has a 2-month-old. They're then married for a period of a few years. They have another child. There's a support agreement that stems out of that. They then, because they separate, so now there's a support agreement for that one child. Mother then tries to make father pay child support in a modification for the support of her other child. He says, no, I don't have any obligation under the support statute to do so. McNutt, as cited by Appellant, discusses, we don't want to disincentivize people, effectively, I'm paraphrasing, to stay involved in these children's lives, to rear them, to do all these great things by the fear of maybe being on the hook for child support in the future. But if we actually look at a little bit more detail in those facts, if we stop right there, Appellant's argument makes a lot of sense. I can sympathize with that to some extent. But if you look at the facts of the case, there's no facts that indicate there was ever a custody order entered in that case. What happened was they were going back and forth. Mother and father then, father was seeing the child. There's no evidence that he was in a custody determination determined to be in loco parentis, which is a specific classification. He He's going back and forth. He's giving her money through this agreement. And at some point, I guess whatever happens in the relationship, they get through the support court. Support court says he's in loco parentis. This isn't a custody order. There's no objection from mother indicating that she didn't want father to come around and see the other child. Father had known this non-biological child since the child was 2 months old. There's no evidence to support that she was objecting to this. There's no evidence to support that the stepfather took substantial affirmative steps, that he filed a petition to get custody over that child. There's none of that evidence.
Let's bring this back to AS in this
Sure.
case. Distinguish how your scenario, your client, fits into the facts of AS. AS, they were married. 2, stepfather had legal custody of the child. Your case, there is no legal custody, and he's not a stepfather. He never married. When you take those facts in consideration with Justice Dobson's argument that 4321, support is obliged against a parent, of which the appellant is neither.
Sure.
So are you asking us to dismiss the strict construction of 4321, and we should overrule AS by saying now you don't need a form of legal custody in making important decisions when trying to support? Do you understand?
I understand your question, sir. I don't believe that ASVIS necessitates that legal custody must be entered. What ASVIS states is that when a step-parent, they used the step-parent because that was the factual scenario in that case.
Because it's consistent with the support statute. But go ahead.
But, well, if I could jump in on that point, step-parent and parent, or step-parent doesn't appear in the support statute. There's no difference. You don't have an obligation of support because you're a step-parent. And actually, I believe the McNutt case I was just talking about
Just ask that question.
inappropriately blends the two for some reason. I think the step-parent is a red herring. It is of no relevance at all. But in ASVIS, when that step-parent does substantially more than offer gratuitous love, as Appellant said, and that when he jumps into a litigation to achieve all the rights of parenthood, and then they implicate this paternity by estoppel. But what they're talking about there isn't, they got the same rights, they got equal shared physical or shared legal, they just got the rights of being a parent. You as a parent could have the right to have supervised visitation and have 1 day a year. You still pay support as a parent.
So if we follow your scenario.
Yes.
And these two individuals, the non-custodial parent that you're seeking support from, this individual, not even say parent, the non-custodial in loco parenti individual.
Yes, yes, sir.
You're requesting that they pay support to the custodial parent for, let's say, sending their children to to be indoctrinated in a particular faith that's not the non-custodial, and it's offensive to the non-custodials. Let's make believe that they want to send them to a Ku Klux Klan education.
Sure.
It's your position that because I have physical custody of the child but nothing else, I have to pay when I'm Catholic. They don't like Catholics.
Understood.
Why would I want to support money to an individual who wants to educate the child to hate me?
Number one, sir, you're supporting the child. Understood that those two blend.
We're educating the child to hate me and my entire family.
I understand that. The obligation to support, I would answer your question directly, the obligation to support, yes, it does exist, assuming that they meet my test that I'm proposing, that, yes, they do have an obligation to support. Now, the question of whether or not they would be, how much they would pay, they would be responsible from an extracurricular or religious type environment, whether they would have to be forced into that at all, that's a question for the trial court, the fact finder, to determine whether or not there's a deviating purpose from the support guidelines.
I understand.
Right. Absolutely.
So I understand it. But the fact remains, under your framework, you would be forcing me, as a non-custodial, to pay to send my child to get an education, so that when I say, with my physical custody, come on, it's Christmas, we're going to Mass, he turns around and says, you heathen, you this, I can't go.
But, so Your Honor.
And that's supposed to bring unity together to this family.
I would posit the following, though. If you are a parent and you don't have shared legal custody, the other parent has sole legal custody, can make all the determinations, you'll still be obligated to pay support. So the hypothetical of the parent, which I would view in loco parent and parent as the same, effectively, and that's...
The General Assembly doesn't view them the same.
Well, the General Assembly states them differently for the purposes of standing. Yes, I agree with that. But what is clear in the case law through in loco parentis and discussion of it is that they've done enough to literally step in the shoes and act as if they were a parent.
Well, so does a school district. But we don't say that the school district, when they're acting in loco parentis, is a parent.
Unfortunately, I'm not educated as far as school law and all that stuff, but I would accept your representation. I do think that they are substantively different because you're talking about the legal and physical custody rights of that child that are implicated.
Can I ask you just this question about AS? Because again, I'm trying to. Why am I wrong to look at AS as a parenthood by estoppel case? That here you had someone, not the biological parent, not an adoptive parent, but someone who affirmatively argued at every step of the way, including through custody proceedings, I am the parent. I am effectively the parent, and nobody's going to tell me differently, and that's why you have to give me partial legal custody and visitation and all the things you would give a parent. And then you turn around and say, okay, you won. We're now going to seek child support. And then all of a sudden that person goes, oh, well, wait a minute. I'm not a parent. The principle of parenthood by estoppel would say you can't mount that defense. You're prevented from mounting that defense.
I agree.
Why isn't AS just that, where it basically says when you have asserted parentage in such a way, you cannot then later defend against a claim of parentage?
Sure. I think it's a very good question. I think the bright line that I'm proposing with my test, my three-pronged test, is very much that. It fleshes out to the extent of whether or not the parental estoppel exists in a situation where somebody takes the sufficient affirmative steps to move a case forward, and we can break down.
You would agree here that the facts here are not that?
No, I would disagree with that, sir.
You think that this person who has partial physical custody all along has maintained, I am the father?
Absolutely. Yes, sir. Well, no, I don't use the word father. I am a parent. Yes, absolutely. By his conduct. Undoubtedly, in my mind.
What conduct?
He has taken sufficient affirmative steps by filing a petition in the court, not reaching an agreement for some type of visitation outside of a court order.
But a grandparent can do that, too.
Understood. In dealing with the facts of this case, and I agree with that. We can explore that if you wish. But he files in court. He goes to a custody conference. He litigates the issue, has multiple days of hearings. There's an appeal that he responds to, right? These are all, to me, sufficient affirmative steps. Unlike the case in McNutt, where the father, the stepfather in that case, just was seeing the child and there was no disagreement and no apparent objection on the facts. This is somebody where he is trying to actively take custodial rights away, physical rights, which I think the distinction between legal and physical here of not having legal as being this threshold is different, but not drift.
Why shouldn't we have to look at some sort of a Darth Vader moment where it's to the public, to the court, to the other parent, I am the father, or I am the parent. That affirmative representation. Why isn't that what we need?
But Your Honor, he's saying that, in my opinion.
I didn't see anything in this case that said he said that.
He didn't seek legal custody.
Well, okay, so if we want to jump to the legal custody piece of it.
Well, I want you to answer Justice
Sure,
Cross.
I do see that. I think the fact that legal custody is not asked for, sure, it's a relevant factor, but I don't think from my view of the test would mean that it's not substantial custodial rights that he was seeking. That those two don't necessarily correlate, because there's plenty, like in that scenario, you could just ask for 49% of the custody, no legal custody. I don't want legal custody. Who cares? I don't want to be involved with that. No big deal. I want 49% of the overnight stuff. You get it and don't have to pay support.
Isn't the more, or I think maybe the more important issue that really hasn't been discussed here is, in my view, the most important person in the equation is the child. Mm-hmm. And I'm really concerned that creating some standard might be a real disincentive for somebody who's been very important to a child to say, geez, I really can't afford the support, I'm not the parent, and shouldn't that be something that we should contemplate in making this decision?
It's a very good point.
The effect on the child?
And I do believe that that was discussed through this paternity by estoppel, which is mentioned in ASVIS, and what we were just discussing. That I think that issue has already been broached by ASVIS and was handled appropriately by the court. The idea of a public policy perspective of ensuring we don't necessarily want to disincentivize people of being involved in these children's lives is very important. But also what's in the best interest of the child is ensuring that that child is supported. So we can't necessarily just throw away the idea here that we have support guidelines in place to ensure these children are supported and value that one more than the other. I think it's an important incentive, but let's step back a little bit. If the court would agree with my proposal here of what I'm effectively asking is, let's just flesh out ASVIS a little bit more with this three-pronged approach, which they kind of do anyways, but just a little more defined. In a situation like that, then the parent really has to make the decision. The person that wants to step in and become that in loco parent has to make the decision, hey, if I'm going to be involved in this child's life, I'm going to do all these things, which arguably are harder to do in raising a child than just write a check, right? Doing all these important things, this huge undertaking of becoming this child's effective parent, that responsibility weighs more than, okay, maybe sometimes people won't pursue it.
But counsel, during that custodial time with the non-custodial parent, that non-custodial is required to pay for the substance of that child's existence, whether it's 10% or 49%.
Agreed.
So the question becomes, if we're talking about supporting the child, it appears that your argument is the one biological or the biological custodial parent just wants to get money from the non-custodial loving parent based upon the amount of time, without taking into consideration the factor that when the child's with appellant's client, he's required to support, feed, and clothe that child.
Or does he really fundamentally just want this visitation, partial physical custody to end?
Maybe I didn't understand Justice's question. I'm sorry, Your Honor.
My question would be, tell me, the position, what I'm gathering from your argument is that your client just wants to collect money from the non-custodial because they have a lot of quality time with the child because of their connection. And what the factor is missing is, what about the support? Are now we to require the non-custodial to save every receipt for every dime they purchase so they can try to offset in a support hearing?
My client does not want, and in this hypothetical argument here, does not want him to just, the loco parent to just pay money. That's not the point here. What my client wants is somebody who obtains substantial custodial rights and took affirmative steps to do so over that biological parent's objection now has an obligation to pay support under the law.
But you're saying it's spiteful then. There's a spiteful
No,
request.
I don't believe so, sir.
Okay.
I actually don't. That's by law. That would be akin to saying that somebody who just has primary custody, forget the in loco part of it, and they have 90% of the time, and the person sees the kid, they still want money.
We're dealing with biological parents, and the moment you conceive, you accept responsibility.
Okay, that's a fair response, sir. But I don't see the spiteful nature of it. What I view it as absorbing custodial rights puts you on the hook.
Isn't the possibly an underlying motivation here that I don't want this third party to have visitation and partial custody of my child? If I make him pay, then he won't do it. He won't see the child anymore.
That's the public policy concern again. But I would again go back to ASVIS. This is discussed at length with the paternity by estoppel argument. I believe that the incentive to ensure that children are adequately supported, and if you tease this out again to my hypothetical, which is extreme.
I wasn't talking about a hypothetical, though. I was asking about this case.
Of this case, Your Honor, yes. In this case, you have, and we can go through, I know the record is very clear of it, but what the in loco parent has here, he has the second weekend of every month, Friday to Sunday, overnights. He has effectively what I would say somewhat, irregular, but does have overnight physical custody. He has the second weekend in odd months, of all day on a Saturday. He has substantial time with the child in that regard. He has every week a day with the child, a dinner visit after the child, daily requirement, or allowance of telephone contact with the child. He has Saturdays prior to certain holidays. He has, from a quasi-legal perspective, which my brief talks about, that's what I call it, although in loco father didn't specifically ask for legal custody, he has some significant rights that you see above and beyond people that don't have any legal custody.
We don't have such a doctrine as quasi-legal custody in Pennsylvania, as far as I know. Do we?
I agree with that, sir.
Could I just ask him to finish?
Sure.
If you have more to say on my question.
I do, yes, thank you, Your Honor. That he has the ability to pick the child up from school, going to what I'm calling quasi-legal, which I agree is not a term, but the right to, not only just the ability to, the right by court order to participate in school, educational, therapeutic, and medical involvement with the child. Counsel argues, well, he can't decide, he can't change it. Sure, but he's got to be heavily involved in it, and actually could file contempt and ask for him to be punished for not sharing that information, for him not being kept in the loop of all of what's going on from the therapeutic standpoint. If anything, from the basis of this order, there's a lot of custody parents that are going through litigation that actually they get all the information, but they don't get any of the responsibility. Like the result here is significant implications of legal custody, of the impact and the influence that this individual has on his child's life. That's why in my brief, Your Honor, I indicate I don't know where this proverbial line in the sand is. I don't know what substantial custody means. That's for the fact finder to determine. I do believe, though, that the in loco parent in this case crossed that line wherever it may rest.
I think that's a really good answer. And if we had a thing called quasi-legal, you'd be probably a good example. Your client would be a good example. Anyway, to your credit, you've proposed a test, and I commend you for that. I just wonder whether, since we're sitting here in the Capitol, there's these other folks here. They're not around. I don't know if they're around very much, but the General Assembly, maybe they should be the ones enacting your test. I'm just wondering, they've given us this statute, parents are liable for the support. And this court did its thing in AS. Mm-hmm. And I wonder if we go beyond that and expand this parents are liable for the support as AS construed it, mm-hmm. and go with your test. Are we getting a little far out over our skis here? Mm-hmm. And I guess, let me put it this way. Can you tell us why we should pronounce mm-hmm. your test as a matter of law and not say, you know what, that's a bridge too far for us, the General Assembly should do that?
It's a very good question, sir. My position on this is that the doctrine of in loco parentis, as that has been adopted by this court, has effectively been assumed by parenthood. They effectively have become the same thing. And I think that if you review the doctrine of in loco parentis, you are fundamentally becoming that parent. I do believe, as I said in the outset, I think this standard would be applicable to in loco parentis only. I think that grandparents and the fourth category are different because there's many hypothetical scenarios of a temporary nature of custody in the event of some issue of somebody stepping in, caring, and then backing out. Don't put them on the hook for support until the child's 18. I agree with that. But in loco, you can't walk back in loco. Once you get it, once you're the parent, you're the parent. That's it.
Well, but you don't have to get somebody's in loco parentis status revoked, you don't have to file a termination of parental rights.
You do not need to file a termination of parental rights because there may not be another parent. That's correct. As in this case, sir. Yes.
Yeah, there's no involuntary termination of a loco parentis status petition.
No, you get it. You have it. You are now a parent. So
well, that's assuming if we adopt your view that the General Assembly meant when they said parents, they also meant in loco parentis.
I don't know what the General Assembly meant at the time. What I do know is that the case law since then, as this court and Superior Court has outlined through in loco parentis, has effectively treated them the same.
Well, it's an interesting case. Both of you, thank you. Great arguments, and we're going to figure it out.
Have fun.
All right. Thank you so much. Before you adjourn, Mr. Minner, this concludes our 2023 fall argument session. I'd like to thank PCN for their time and effort in covering this for an educational and informational purpose. The court appreciates that. I'd like to thank our court crier, Brian Minner, our prothonotary, Caitlin Gorman, and our court security, John Evans and Gary Shovlin, as well as the Capitol Police. Mr. Minner, you may adjourn court.
Court is adjourned.